On 17 April 2025, the Supreme Court of India heard a batch of writ petitions challenging the constitutional validity of the Waqf Amendment Act 2025. Among these was a writ petition filed by Lok Sabha MP Asaduddin Owaisi. The petitions were heard by a three-judge bench comprising the Chief Justice of India Sanjeev Khanna and Justices Sanjay Kumar and K.V. Vishwanathan. The court issued an interim order outlining procedural steps for the ongoing legal proceedings, which has attracted considerable attention due to the Act's implications for Waqf property management and religious autonomy. The court directed the central government to submit a preliminary response within 7 days from 17 April 2025. The next hearing is scheduled for 5th May 2025. Several prominent lawyers have represented petitioners opposing the Waqf Amendment Act 2025. Notably, senior advocate Kapil Sibal appeared on behalf of the Jamiyat Ulama-e-Hind led by Maulana Arshad Madani. In this context, a popular social media post claims that under the Indian Advocates Act 1961, Sibal cannot argue against the Waqf Amendment Act in the Supreme Court as he receives a government salary, allowances and pension as a member of parliament. The post further asserts that legislators in India, that is MPs, MLAs and MLCs, are barred from practicing as advocates while serving their term. To verify the accuracy of the claim, we reviewed the Indian Advocates Act 1961 and found no provisions or rules that prohibit legislators from practicing as advocates while serving their term. This act, which governs the legal profession in India, grants the Bar Council of India or BCI the authority to establish rules regarding the conduct of advocates. Subsequently, we visited the official website of the BCI and reviewed its regulations. According to BCI rules, if an advocate accepts full-time salaried employment, they are not permitted to practice law while in that position. Upon taking such employment, an individual is deemed to have suspended their legal practice unless they resign from the position and notify the Bar Council. While part-time or consultancy roles are not automatically prohibited, they may still be examined for potential conflicts with the independence or dignity of the legal profession. Under Rule 49 of the BCI rules, which are framed under the Advocates Act 1961, advocates are prohibited from practicing law while engaged in full-time salaried employment. This rule specifically applies to individuals in full-time salaried positions, barring them from continuing legal practice. However, the role of a legislator, such as a member of parliament or a member of a legislative assembly, is not considered a standard employment relationship under this rule and, therefore, does not fall within the scope of this prohibition. In February 2018, Ashwini Kumar Upadhyay filed a writ petition under Article 32 of the Constitution, seeking a ban on legislators from practicing as advocates during the period they serve as members of parliament or state assemblies. The petition was based on the spirit of Rule 49 of the BCI rules and Article 14 of the Constitution. The petitioner argued that legislators, being full-time public servants drawing salaries from the public exchequer, should not be allowed to practice law concurrently. He contended that holding dual roles could result in conflicts of interest and amount to professional misconduct. The petitioner referred to Rule 49 of the BCI rules, which prohibits advocates from engaging in full-time salaried employment, asserting that this provision should extend to legislators as well. The Supreme Court examined the nature of a legislator's duties and the relevance of Rule 49 of the BCI rules. It observed that while Rule 49 bars advocates from undertaking full-time salaried employment, it does not explicitly prohibit legislators from practicing law. The court also considered previous judgments and relevant constitutional provisions concerning the responsibilities of legislators. On 25 September 2018, a three-judge bench of the Supreme Court, comprising then Chief Justice Deepak Mishra, Justice A.M. Khanwilkar and Justice D.Y. Chandrachud, dismissed the petition. In its judgment, the court clarified that members of parliament, state legislative assemblies and state legislative councils are not considered full-time salaried employees and, therefore, Rule 49 does not apply to them. The court further held that any such restriction must be enacted through legislation and cannot be imposed through judicial interpretation. It emphasized that unless Parliament enacts a law specifically prohibiting such dual practice, legislators are permitted to continue practicing as advocates. So, while the Bar Council of India has a rule about salaried employees being barred from practicing law, as legislators do not face such a prohibition under the Indian Advocates Act 1961, this post is misleading. Join our YouTube membership program and be a part of the journey of making public data meaningful. And remember, before you hit that forward button, pause.